I'm Chloé Marnet-Bassanger, and I'm the team leader for the UN team of experts on rule of law and sexual violence in conflict, and it's my pleasure to be moderating this panel today. About a year ago, the UN team of experts decided to collaborate with the Journal of International Criminal Justice on a special issue to commemorate 10 years since the operationalization of the UN team of experts by the UN Security Council. During that time, we have witnessed progress in national accountability efforts to address sexual violence in conflict, but we've also encountered many challenges. The focus of the digital dialogue series, which this webinar is inaugurating today, is to explore the themes of the special issue and delve further into those issues in order to push the agenda forward and consider possible ways to advance accountability at the national levels in the coming years. One important aspect of national accountability efforts that came up in a number of articles, including in your piece, Kim, is the need and the importance for partnerships and sharing expertise about investigations and the handling of victims and witnesses. Our next panelists are Karen Naimer and Daniele Perissi. In addition to being the contributors to the special issue, Karen Naimer is the Director of Programs for Physicians for Human Rights, and Daniele Perissi is the head of the Great Lakes Program for Trial International. Daniele and Karen, your articles discuss the importance of multidisciplinary cooperation in national accountability efforts. In the DRC, Trial and PHR partnered together on the Kavumu case. Other international actors like the UN team of experts and the UN missions were also involved in supporting the effort. Could you maybe discuss with us and enlighten us a little bit about what innovative approaches did PHR and Trial International, as well as their partners, use to support national judicial authorities in this case, particularly regarding the development of a strong medico-legal cooperation?
Thank you. It's a privilege to participate in the dialogue today. The special issue highlights the emergence of a quiet revolution where national courts are taking the lead in adjudicating cases of conflict-related sexual violence and serving as a crucial venue for accountability and access to justice for survivors. This is propelled by courageous clinicians, police officers, lawyers, and judges who assume significant risk by pursuing these cases in their own communities, and by strategic partners like the SRSG and the UN team of experts who provide technical expertise and a key political platform to support this work. The landmark Kavumu case in DRC illustrates this point. In 2013, clinicians at Panzi Hospital in South Kivu started to see cases of young girls between the ages of 18 months and 11 years from the nearby town of Kavumu, presenting with the same story. Each time, the child was abducted from her home in the middle of the night, taken to a nearby field, brutally raped, and then abandoned. The injuries sustained were similar too, and the severity shocked even the most experienced clinicians. Over 3 years, more than 42 young girls from Kavumu arrived at Panzi Hospital, where clinicians trained by Physicians for Human Rights documented the forensic medical evidence in each case. The community in Kavumu was so terrorized by these attacks that activists from the town joined together with clinicians, police officers, and NGOs to mobilize a task force for justice to support investigations. But the local civilian magistrate refused to launch one because, as we learned later, a powerful sitting member of provincial parliament and the militia he controlled were suspected of carrying out the crimes. While the investigation stalled, Physicians for Human Rights collaborated with the task force and Dr. Denis Mukwege, founder and medical director of Panzi Hospital, to bring international attention to these cases and to pressure the Congolese government to act. We also partnered with the SRSG and the UN team of experts who amplified the call for accountability and urged national authorities to prioritize the prosecution of these cases. And we joined forces with Trial International, a Swiss-based NGO, which joined the task force and helped to support the Congolese legal team representing the victims in the case. Because of this serial and systematic pattern of the attacks, military authorities took the creative step of aggregating the cases and framed them as a single case of crimes against humanity. This innovative legal theory allowed military justice to assume jurisdiction over the matter in 2016, which infused a new energy into the investigation. Within months, Congolese officials arrested dozens of militia members, including the powerful sitting member of parliament, Frederick Batumike. Immediately after the arrest, the crime stopped. The case was complicated, though. Not only did Batumike instill enormous fear in the community, he also enjoyed immunity because of his status as a sitting lawmaker. The task force worked with national authorities to remove Batumike's immunity so he could stand trial. And by September 2017, the military prosecutor indicted 18 defendants for acts of rape constituting crimes against humanity. After a 5-week trial in December 2017, a mobile military court convicted 11 men, including Batumike, of crimes against humanity for the systematic rape of dozens of girls and sentenced the defendants to life in prison. They swiftly appealed, but in 2018, the High Military Court confirmed this landmark decision. The judgment marked the first successful conviction of sexual violence as a crime against humanity in the DRC for a sitting lawmaker and for serial crimes. And it marked the culmination of 5 years of groundbreaking work, especially by Congolese medical and legal professionals who led this effort and were powerful agents of change in their own communities. I want to highlight 3 important lessons learned. First, the coordination between national and international partners was a fundamental feature of the case. Dealing with complex mass crimes requires a combination of expertise, including criminal investigation and prosecution strategy, collection of evidence, legal analysis, use of forensic medical tools, security, logistic support, and advocacy. To achieve this, coordinated action is key. The Justice Task Force, comprised of grassroots activists and professionals and international partners, embodies that collaboration. Second, the case confirmed the power of medical legal collaboration, especially for gathering comprehensive forensic evidence and for victim and witness protection. As the prospect of a trial loomed, the idea of the young survivors appearing as witnesses in court became deeply concerning. So investigators and prosecutors worked with the clinicians, the survivors, and their families to pursue a trauma-informed strategy. The judges allowed the child survivors to be interviewed and recorded by forensic clinicians with informed consent. During the trial, the court referred to the recordings in lieu of compelling the survivors to appear as witnesses. This approach was unprecedented in DRC and spared the children from being intimidated by the militia members sitting in the dock and the hundreds of spectators watching in the public gallery. And third, for sustainability and scale, it's critical to invest in the capacity development and mentoring of national medical, law enforcement, and legal professionals on gathering forensic evidence, investigating and prosecuting mass crimes. These professionals are agents of meaningful and sustainable change in their communities, making it harder for judges to deny or dismiss evidence of criminal liability, even for powerful actors. The lessons of the Kavumu case are already having an impact, and the innovative approaches are now being replicated in other cases in DRC. With national and international coordination, medical legal collaboration, and investment in local justice processes and people, more survivors will obtain their day in court, and those who perpetrate these crimes will be held to account in their own communities.
Thank you. Thank you, Karen. We have an issue with the... Thank you, Karen. Thank you, Karen, for this extremely interesting account of the Kavumu trial. I think all of those of us who worked in the Congo remember where we were when those trials were conducted, and certainly distinctly felt that there was a message of hope for all of us and the victims when this came through. I think what you gave us here was also an excellent lessons of what it means to work as one and leveraging all of everyone's expertise, and also questioning status quo. I think the legal innovation you mentioned are absolutely a case in point, and a number of things that we need to learn from. What I find interesting in this case is also that there's a lot of lessons that can be learned, but have not necessarily been learned and replicated elsewhere. They certainly have served well the advancement in the Congo itself. But in fact, these are areas where we could use and leverage some of the strategies and tactics and modus operandis and partnerships that were leveraged in the Congo and have not yet been leveraged in other contexts. We'll turn now to Daniele for a second part on the Kavumu trial. Daniele, the floor is yours.
Thanks a lot. Thanks, Chloe. Indeed, as Karen was mentioning, the hurdles that we faced throughout the years of investigation and prosecution of the Kavumu case were very numerous. I just wanted to highlight one of the main hurdles that we faced during the time we worked, and that issue was the issue of domestic communities. Because as you understood from Karen, the theory of the case was that the militia committing the crimes was organized and directed by a provincial lawmaker. Not only was he the most important public figure in the area, enjoying de facto protection from the local authorities, but he also enjoyed legal immunities from prosecution according to the Congolese constitution. And we all knew how difficult it is to overcome this legal barrier. Even looking at precedents in state practice from other countries, there wasn't much. Maybe you are familiar with the Rios Montt judicial saga in Guatemalan courts. Even there, the former head of state was prosecuted eventually by domestic courts, but only after the end of his term in parliament because of his domestic immunities. So the legal strategy that we devised revolved around the use of the Rome Statute of the International Criminal Court as a tool to push forward accountability at the domestic level. And it's interesting, as Kim noticed, to note here the articulation between the two levels, the international, the Rome Statute level, and the domestic law level. So the Congolese constitution stipulates, as many constitutions do, that duly concluded international treaties have an authority superior to that of domestic legislation. Plus, thanks to persistent advocacy throughout the years by human rights groups and civil society, the DRC had, in 2016, introduced the Rome Statute into its national legislation. And the relevant national statute explicitly includes the text of Article 27 of the Rome Statute. Now, Article 27 is the article that affirms the principle of irrelevance of official capacity, meaning that basically, as far as international crimes are concerned, the law shall apply equally to everyone without any distinction based on official capacity. Therefore, our argument went as follows. If it's true that sitting parliamentarians enjoy immunity from prosecution according to the Constitution, the principle of irrelevance of official capacity in cases of international crimes, as contained in the Rome Statute, but as also integrated into domestic law, has to prevail over the constitutional immunity provision. And this is consistent with the drafting history of the Rome Statute, showing that this article was intended to have effect not only before the ICC, but also in national proceedings for atrocity crimes. So this is in a nutshell the argument, the legal argument that won the day in the Kavumu case, and thus prosecution was possible. So in conclusion, I just wanted to share a couple, I think, of lessons to be learned and strategies that can be applied also in other contexts. In particular, first of all, for activists, but also for policymakers, the importance of using the Rome Statute. and the importance of how the Rome Statute and in particular its immunity rules are implemented into national legislation so as to render domestic immunities irrelevant for international crimes. Secondly, for researchers and for the legal community at large, the need to deepen the understanding of the interplay between the Rome Statute and domestic immunities for international crimes. I think that the Kavumu decision shed some light on this issue, but further research and further application, hopefully in other jurisdictions, would certainly be helpful to better delineate the contours and the scope of this principle. Thanks.